Hey, it's Mr. Dwoski here, and today we're going to talk about copyright in the public domain. So, what is copyright? Well, it's a protection of intellectual property. Most content accessed on the web is protected by a copyright, and these apply upon publication or creation without you having to take any action of your own. Now, one thing that you do want to take into account is that if you apply for a copyright, you will have stronger protections for your work, and you'll be able to seek legal remediation if somebody uses it without your permission or in a way that you don't want them to do. You do not have the legal right to use images or content without permission, especially if you're looking for profit. The rights of these creations belong to the copyright holder. Now, limited use may be legal underneath fair use, which we'll talk about in a few minutes. It also, copyright grants an exclusive license to the copyright holder. So you own it if you create it. Now, every country views this a little bit differently. For example, France has a vastly different law regarding their artwork than the US does. So it also has, depending on where you're located in the world, you have different copyright time frames. So how long can something be copyrighted for, and how the copyright law itself is interpreted. One such example is that the EU, so the European Union, introduced Article 13, also kind of known as the meme ban on the internet, holds platforms responsible for copyright infringement and requires the use of automated filters to detect content. Now, this gets to be a little dicey because filters can't tell the difference between something that's protected, like a parody, and willful copyright infringement, such as copying something and putting it on your own website. So this is a little bit of troublesome to look at and try to figure out where does this fall within fair use versus um, copyright protection. Considering this basically tells websites that rather than going through and monitoring the content posted, they have to have more proactive approaches to it. In the U.S. especially, it gets to be kind of troubling when we talk about not just our rights there, but free speech. So what is copyrighted? Well, books, movies, music, plays, trademarks and logos, fine arts and maps, basically things that have some creative aspect to them. Things that can't be copyrighted are names and short phrases, common knowledge, things that people know just by default, things that are um, anything that does not show creative or original authorship. Also to take into account is things that are protected by patents. These are slightly different than copyright. Patents protect ideas, procedures, discoveries, things that are, like scientific in method or, medical findings. It's also important to note that Disney has been an important influence on the change of copyright laws due to lobbying. Now, the graph at the right shows how copyrights have been extended every time Mickey Mouse is scheduled to fall into public domain. Originally, copyright laws only protected things for shorter time periods, like 20 or 30 years, and successively over the years, those protections have been extended, most notably, again, every time Mickey Mouse is about to fall into public domain. So what this would mean is that we could use Mickey Mouse to create our own works with that character. Disney does not want that. So for more information, I would really encourage you to read How Mickey Mouse Keeps Changing Copyright Law. Um, Fair use is an exemption to copyright laws. It's a balance between owner rights and educational interests, and it eliminates the need to pay royalties. So limited use is protected for educational and critiquing purposes. And you can also use small snippets for news reporting and for satire. The key here is that it is smaller, it's more brief. These are protected. Things that aren't protected would be longer uses of these. Other things that we need to weigh in determining fair use or copyright infringement. So is it commercial use or is it educational and nonprofit use? What is the nature of the format? So is it a book or is it a newspaper? And then the amount used. So again, smaller is more preferred. And then you also have to think about the effect of its use versus the marketable value. So if it's something that just came out and you're using it, again, smaller is better, but is it going to impact the creator's ability to make money off of the product? So one thing to take into account with this is how James Boyle, Center for the Study of Public Domain at Duke, he said that we are the first generation to deny our own culture to ourselves because no work created during your lifetime will, without conscious action by its creator, become available to you to build upon. Copyright law is currently lifetime plus 70 years. So with that in mind, works that belong to the public are things that are past that extension or things that came prior to that law being put in place. Items that are now in the public domain include things that were not copyrighted, things that are lost or expired copyrights, and government documents. So there are some things that are in the public domain. Books that are 100 years old at this point would likely fall into public domain, which means that you can use them. You still need to give credit to them, but you can access these freely and make copies without fearing copyright infringement. Now, these can also be limited based on contract law. So you can legally access public domain documents, but contract law, which is legally enforceable, things like Ancestry.com, Family Search, places where these free public documents are given, if you enter into a contract, so whether it's a click wrap, browser wrap, so something that's just in the terms of service for the website, or something where you've clicked through and maybe you haven't read it, these documents are legally enforceable, which means that broken agreements can lead to them revoking access to you. So contract law is enforceable. You can't necessarily copy something, even if it is in the public domain, from a website that bans you from redistributing content that they are providing to you, even if it is in the public domain. It's kind of antithetical, doesn't make a lot of sense, but it protects their rights. So this is another thing to kind of take into account. Now, Creative Commons is where owners relinquish their own rights. This allows for a more global community of sharing resources, and it's different than public domain. Maybe some items that are in public domain are covered by Creative Commons, but typically Creative Commons tends to be intentionally open to the public. This is intentional with authors giving up their rights to own something. So there's several different licenses and icons that determine when you're looking at something. So Creative Commons licenses, public dedication, things where you have to give credit to the author, where you can only use it for non-commercial, you can't resell the image, for example. Things where you can't change the image or adapt them, or if you do adapt them, you're not allowed to sell them, or it needs to be within the original terms of use. So just some things to think about. Is it fair for large media conglomerates to lobby for extending copyrights well beyond their lifespan of the creator? Argue your point. What implications can this have on the development of society and culture? And lastly, put on their shoes. How can we ensure fairness to the rights of both content creators and accessibility to the public at large? Are current laws serving these needs, and what changes would you make if you were a legislator? Here are some of the free resources that you can use. So video and audio, images, and clip art, flat icon and free pick are awesome. And here are my references.